Eugene also has a lot.
They do have an even number.
It's probably one of those situations where the mayor doesn't vote except during a tie or something.
Never vote then.
Well,
Somebody was
there.
yeah.
I was recused.
I'm sure it's something because.
Yeah, it's a strong mayor form of government.
College change.
Thank you, sir.
All right, I'll call to order this work session. And Bonnie and the Judge.
Sounds like a movie title.
I was trying to. I said it in my head, and I went, I know there's some clever thing I could say there, but I can't figure it out.
We've been shopping around the story, but it hasn't been done yet. Trying. Good evening. How is everybody? Staying cool, right? Staying cool. I have a very brief update because there hasn't been much going on between April and now. Attendance court discussion has been ongoing. I met with the district again in June, and didn't appear that a lot had happened since the last meeting. Their goal between the time that I met with them before and June was to have kind of their process in place. And they hadn't really gotten there. I think, end of the school year just kind of took over. And so they hadn't had the time to get everybody together and to figure out what their plan was. So they, between June and then August 1st, they were going to be meeting again. I did get an update, what did I say, July 20th from them that they feel like now they've got their process kind of worked out. They're finding, they wanted to take on finding classes that families could go to. I offered to do that. They simply wanted to take it on. They felt like they already kind of had a good grasp on what was out there, and they wanted to craft something that would address the needs that they see. My request was that it fit kind of our calendar of it needed to be a month-long thing and it needed to be offered monthly, or else I end up where, if you're here in January, you can take a class. Sorry, there's nothing in February. And so they were really working on that, and their update on the 20th said that they've got some classes, they've got their plan. We need to be doing an intergovernmental agreement with Clackamas County. And that's what I've been working on. They are ready to move as soon as the school district is ready to move. The school district is drafting that, but as of yet, they have not gotten back to me to say that they have it drafted for us, for the city to review. And then we have to get it to county. The county's got to run it through their legal counsel to get it signed, so that they're giving authority for the city to hear basically what would otherwise be county cases.
And is that just kids in the unincorporated county, or does that also include Happy Valley?
So it'll be all North Clackamas
School District?
Yes.
Okay, so Happy Valley does not have
they don't
attendance court?
No, their folks went to Clackamas County Circuit Court.
Okay.
So it would be the circuit court saying anything that we previously heard, anything that was in North Clackamas School District will now come here.
Okay.
There is one other route in which we can do that, which is just by statute. They can assign their cases over to the court, but that wouldn't cover then any of the financial agreements with the school district. And so we're trying to do it all in one. if things keep lagging as they are, we might need to go the other route just to get it done, because I'm a little concerned that school starts very soon, and we haven't gotten, we being the whole of us, have not gotten this put together yet. Supposed to have a meeting with the school district within this next week, but they have not scheduled yet. So hopefully within a week or so, I'll know whether we're going to actually get this up and running by October or November, which would be the goal. And then aside from that, we talked a little bit about the amnesty program. So Bonnie and Carla and Ann have all been working on what that plan would look like. We just kind of discovered through talking to other cities and looking what they did that tax time is when you want to do it, when folks are going to get a chunk of money back and be able to put it towards something like this. So that kind of took the pressure off, and the plan now is to look at beginning of 2019 to have something in place by then. So this is kind of the planning and fleshing out what that amnesty program will look like, what's going to qualify, and how we're going to work with collection agency to do that. And that's about it.
Cool.
Anything anybody else was thinking of, wondering about?
So just the normal court, you're having one session a month now, or not even?
We're having two.
You're having two?
Yeah. Okay. The trial dockets in the morning are still full.
Okay.
Yeah, they're still full. I mean, we start the first one usually at 9, and the last one's at noon. And, you know, aside from if it gets pulled off because they've hired an attorney or if an officer can't be there, those mornings are still full.
So how long blocks do you allow for each trial?
15 minutes.
About 15 minutes.
Yeah.
Okay.
Unless it's something, you know, where they let us know ahead of time or whatever time schedule.
They're going to have a witness.
Yeah.
You can speak, unfortunately, you need to.
Oh.
It's usually about a 15-minute block, and usually that gives the defendant enough time to testify, and the officer, and then the judge to listen to all the evidence and make her decision. Unless it's a situation where we know it's going to be a more involved case, and then the officer, or if it's an attorney, the attorney will let me know, and I will block out more time, sometimes a half an hour, 45 minutes. It just depends on the case, but
Do they
majority.
have to tell you in advance if they're having other witnesses than the
Yeah, usually,
person
because
who's
we know
ticketed?
there's going to be a lot of witnesses that usually will require more time. So
Right.
usually we like to know ahead of time if they're going to have a witness list. Or if they want me to subpoena them, sometimes they need a subpoena. They will have to notify me so I can type the subpoena for them.
And right now, we're setting out usually about 2 months. So those dockets are staying full. The afternoons are definitely slower than they'd been. So, but yeah, still twice a month.
Anybody else? Anything?
Nothing. Great. Yeah.
Thank you very much.
Good to see you.
And stay cool out there.
You won't have that problem in here.
No.
No, we never have that problem in here. why we all
winter,
bring
summer?
coats
It's like a
and
wine.
jackets.
It's like a wine cellar. Winter, summer, it's always 60
Worse than a wine
degrees.
cellar. Arctic
Honest.
snowcat.
Have a good evening.
Do I have a work session agenda?
I'll grab one.
So I could pull it up on my,
It's Reba.
yes.
Yeah, it's
Talk about rights of way.
Rights of way, ordinance revision.
Most exciting topic in the city.
Yeah,
Most exciting topic in the city.
Don't forget to announce the exact.
right. That's why the main thing I was looking for. Okay.
Ready?
Sure.
All right. Well, today I'm going to talk about the Title 21, the road code. As you remember, we adopted this back in September of 16, effective January of 17. Overall, the code has been really successful. Just as a brief recap, since it became effective, we've approved, as of yesterday, 40 row licenses for the city. Telecom revenue has gone from 3% to over 22% of the total row revenue in the city limits. In 15-16, the telecom revenue was $60,000. As of right now, when we're not done collecting the fourth quarter, it's $452,000.
Wow.
Additionally, through the identification of the electric service suppliers, we've collected an additional $230,000 in revenue, $23,000 in application licensing fees and business registrations. So I'm a little excited, sorry. Yeah. That's about $735,000 in new revenue to the city in 18 months. So it's been really successful. The reason we adopted this is so we could be resilient and adaptive to changes. So in the past 18 months, we've been chasing road providers, gaining some more knowledge, and we have some changes that we'd like to make. And I know that you have some questions. I know that you've read them. So I have the red line, and I know you received it, so I just wanted to address any questions you have about the changes we'd like to do.
I had a couple of questions, and they weren't really substantive, more just, I think a word is added or subtracted, but I just wanted to double check. Starting with, on the definitions for city standards.
Okay.
Page 50, work session, page 5.
Counselor, if you could use your microphone, thank you.
5, you said?
Yeah, city standards. Does, when it says in effect at the time of any work is subject to, that, did we just mean in effect at the time any work is subject to? The of seemed like...
And Lisa asked this question as well, we need to put some commas in there to make it more correct. So it would be city standard means the Milwaukee Public Works and Engineering Standards, comma, in effect at the time of any work, comma, is subject to this chapter. So
okay,
when the work is done, it has to comply with codes. We can't put a new standard in effect and go back and say, oh, well, we put this,
comply, okay.
Yeah.
The commas would help then.
Yes.
On control, which is a new definition, it means actual working control over utility facilities in whatever manner exercised.
Correct.
That seemed so broad, I was trying to figure out what we were trying to fix by adding that definition, which to me didn't add much.
What page are you on?
Work session 5
still, control.
That was actually a suggestion by Nancy Werner when we had her on staff, so she said, make this clear. So, okay. I think it just, later in the chapter when we talk about control and using facilities, having control of it would be if somebody doesn't own the facility, but they actually use it, so they're actually controlling it, so they would be still subject to the chapter.
Even though they weren't the owner, that's the point she's trying to get at?
Because the small cells are coming.
And that's not covered, because we also have operators and
providers.
And you're saying there are people who are neither operators nor providers, but somehow exercise control.
I believe they're both. I believe that.
Okay.
But it was added just for clarity, just to make it crystal clear, because the small cells are coming, and other jurisdictions have had issues with people saying, well, I don't provide and I don't own, but they actually do control who uses it or the service that runs over it. So we just wanted to make it crystal clear that anybody using our rights of way to make a profit needs to compensate the city for that use.
Okay. On work session page 9. At the very top, it's E, licensing fee. And it says if the city determines a right-of-way license fee shall be issued, the application shall within 30 days? Do you mean the applicant?
I do.
Okay.
Thank you.
And then on page 17, at the very top, number 2, where it starts with all construction locations, within the right-of-way shall be coordinated as may be ordered? Is it missing a word? As may ordered?
Maybe, yes, you are correct.
And that was all I had.
Well,
It wasn't really substantive.
That was easy.
Well, I already sent you my resolution question.
Oh, okay, I was going to say.
And that was the
That one I sent separately.
And that was the old resolution. I just redlined it to show, and you guys did catch my spelling errors. I appreciate
Yeah,
that.
I looked up that word. I was like, is that a word? I don't know.
What's the word?
Replening or something like that, wasn't that it?
Yeah.
Replening?
Yes, I have one question. On page, work session, page 9, new item G, or now term G. I'm not sure I'm understanding the latter, actually the second sentence, I guess it is. That first sentence is very long. The second sentence says, the franchise may conflict with the terms of this chapter with the review and appeal of City Council. And before that, it says that it can be changed. They can enter into a written franchise agreement that includes terms consistent with law, and then says it may conflict with the terms of this chapter with the City Council's approval. I don't understand. I mean, I understand what that means, but I'm like, I don't understand why we do that, I guess.
Well, we did change it to that it is the city's option to enter a franchise if we choose. For example, cable, we would always want to franchise that and not place that under the code.
Okay.
But this gives us the choice. And when you do a franchise, what it does is it does change the requirements. Otherwise, they'd be under the code. So we want the option to do that if the public interest is served by doing a franchise. And the reason you would do a franchise is to change the terms. So the franchise would control, not the code.
Exactly, yeah, okay. All right, thank you. That helps clarify that and why it might conflict, and yet if City Council says it's okay, that's okay.
Right. For example, cable, we can only charge 5%. The code calls for 7%. So we would change it in a franchise to 5%, and the franchise would override the code.
Yeah, okay, gotcha. Thank you.
Absolutely.
Other than cable, would there be any other example in which you think that we should do a franchise versus a right-of-way license?
I think that the future is uncertain, and I think with small cells and the fact that they need so many more small cells to cover the same area as a macro cell that we may want to enter into a franchise for providers to put up 100 small cells in the city versus a macro tower. So that might be a different cost analysis.
Okay.
And we could also go back and change the fee resolution as well. That if they, some cities do a sliding scale. If you put up 1 tower, it's this much. If you put up 1 to 10 towers, it's this much. So there's a lot of options out there that we could consider when that does come up.
Okay.
The row license that we approved yesterday was the first infrastructure provider that does not provide any services. They are just building infrastructure for small cells.
And so what is it that they put out there?
Well, right now they're requesting, they are falling underneath the chapter because they only want to put up 2 sites. So they would fall underneath the code. If at some point they decide they want to put up 100, 200 cells in the city, we might want to look at a different cost option because $5,000 per year per attachment could be pretty cost prohibitive for them. And we want this technology. We want faster, better service in the city. So we do want to we want them to come, and we want to make it, they have to make a profit. We can't price them out of our city, and we have to be competitive with other cities as well. So it's just small cells have not really been set right now with other cities either. All of us across the nation are actually talking about this and how to charge them and how to make it fair for them, fair for the residents, and still get the new technology in our cities.
But if the applicant was not the small cell provider, then what is the infrastructure that he's putting in?
Fiber.
He is putting up the actual cell site, the actual equipment.
Okay.
They are not providing service through it. They are not charging any end users. So what they do is they'll put up this site and they'll say, okay, if you want to provide service through this site, we'll carry the signal for you and interconnect it, but they're not actually providing the service. They're not a local exchange. They're not interconnecting. They're just basically they build the road and other people travel on it.
Yeah.
And so at the point where somebody says, I want to travel on your road, that provider has to come in and come within our...
It is a requirement by the code that not only the owner, whoever builds that road, is in our rights of way and has to compensate the residents of Milwaukee for that use. Whoever uses that road and creates a profit has to have a license, and it's a requirement not only of that person, but the person that owns the infrastructure itself is required to check with us before they let somebody use that road that they have our permission to use it. It is our rights. It belongs to the residents.
Wanting to get at. Okay.
So at the very beginning, there's a 2104-020, which is on page work session 3. It's a whole paragraph that's crossed out, and it talks about that we're changing sewer and just calling it out as sewer and water. My concern is that what if at some point we become a provider of fiber, and like we're in the ISP? Does that, then do we have to go back in and add that in or change things because it's no longer?
Possibly. We took that out because we changed the way utilities are defined, and we took out anything water related. We also took out services provided by other municipalities because other jurisdictions may become internet service providers using our row.
Well, Clackamas County already has fiber through.
Well, I was trying not to name names. If at some point they become an internet service provider and actually make a profit here in our city, they would have to pay us a row fee as well. If we decided to lay dark fiber or become an internet service provider, we can always go in and amend this saying that services provided by the city of Milwaukee. And we could do that now if you wanted to. This is just a cleaner way to do it at the time being. If we ever did decide to become, if that was a direction of council, is to be an internet service provider or lay fiber, it wouldn't happen in a month.
No.
So we would have we would have some time to adjust the code because there would probably be other adjustments and other changes we would need to make to make that a feasible thing with our code.
All right.
Well, but while we're talking about that, this was one of the comments that same paragraph, this is one of the comments I had exchanged emails with Reba about. So there and another place further down, and maybe more than 2, we take out the reference to sewer, water, blah, blah, blah,
And storm.
Storm. So, I mean, that makes sense to me, but I guess because the title of the thing is utility service, I feel like it is reader-friendly for it to say up front, whether that's that paragraph we're striking or whether that's a second sentence in the title, somewhere for it to say this section does not apply to stormwater, wastewater, and water services provided by the city. I just think in the terms of, because I could see somebody digging through here looking for that or assuming it applies to that. So I think it's better to just say up front, this doesn't apply to those things.
And I see your concern. And when I went right away and I looked at our code online, and I think it's Title 13 says public services that addresses the water and sewer. My thought was, and of course I'll do whatever you guys direct me to do, my thought was that the only people that are going to look at this title as far as how it relates to any water services, are the people providing water, which, except for a couple pipes owned by Wes, that's us. So I see your point, and I think it's valid, but to me, and maybe it's just the tiny little world I live in, when we say utilities, we basically mean telecom and the things that surround that.
See, I don't think the average homeowner thinks that way.
Right. We call it Citizens Utility Advisory Board.
Committee.
Right. I see the point.
Right.
And in our urban growth management area, we will have pipes provided by other substantial, because I believe Clackamas River Water supplies most of the water out in that area. So as we start annexing out into that, there'll be a whole lot more.
And there already are.
Water infrastructure.
So do you want me to leave a sentence in that for the purposes of this chapter, any water-related services, water, sewer, storm, are excluded from the chapter? Because I would think that when we do expand those, that would be dealt with underneath, I think it's 13. I'm sorry if that's incorrect. Public services for our water.
I mean, just for reader, for being good to the, helping the reader, ease of readability, it's nice to cross-reference that too. But
okay. I
definitely think just, I could see somebody who thinks they have some utility issue and they're digging through this. So, I mean, like I said, I don't necessarily know that it's your A that you want to strike, or is it something that goes up to the title, but just somewhere that says this section does not apply to water, wastewater, and
I can rephrase it a little bit, check with legal and make sure that it doesn't make any changes to what the code does, which I don't think it will, but we can definitely, absolutely.
As long as we're for sure that it doesn't want to. I mean, can we think of a situation where we've got, say, some large company that's running water lines because they have ionized water that they have to use at 2 different facilities, and they're...
I think the nuance associated with that would be pretty substantial, and right now it doesn't cover those areas. We would have to come back and redo code if we wanted to assess any sort of fee. So I would add the language now and then make a conscious decision at a future date if you want to change it. And I just wanted to clarify that we don't charge right away on any of those services, and as the mayor noted, there are other companies within the city that do provide those services. Later tonight, we're going to talk about a letter to Wes very specifically on this topic. So I just want to call out that we are not assessing this on any of those services.
And that's our intent, is that we wouldn't going forward, as opposed to just saying city services are not going to get charged this number.
Correct.
What they are, fiber, sewer, what doesn't matter. We're not going to charge ourselves to use our own streets, but we would consider doing.
I think you could choose that, but I think at that point it needs to be a conscious decision that we're going down that path. Right now, this does not contemplate that we're going down that path in any way.
So we know that we have some homes on the eastern border and that are served by Clackamas River Water now, and we know we have some homes on the southern border that are served by Oak Lodge now. And maybe we have some on the northern border that are served by Portland, I don't know. So those, we don't charge them for any,
No. When we originally talked about doing this code, the conversation that I had with the city council at that time was that we did not want to charge for water and sewer, specifically ourselves or other jurisdictions. It was a decision that council made not to charge other municipalities for the use of our rights-of-way.
Actually might be a great line to include in our, well, we already said that one. Yeah.
Mr. Mayor, one thought you might consider is, for clarity, is taking a look at the titles we have and the names for the titles of the chapters, because this title is called Utility Service. It's really a right-of-way regulation. It might bear thinking about what we call it. We have another chapter which is 13, called Public Services. Maybe that's appropriate, maybe it's not, but getting some clarity between those titles, so at least when you're looking through the chapters, you end up quickly in the right area.
Right.
I would like to add to that most cities call it a utility services code, and I think for ease of the providers, it's might be nice to keep it that way because there's so many jurisdictions in Oregon, and these are nationwide providers that come look at our code and are looking for the utility service code. But with that being said,
do we ever do like subtitles on our?
Yeah, we can do that. Yeah.
Maybe we could do a subtitle that literally calls out what it is and isn't.
Mm-hmm.
Cool. Anybody else have anything else?
I had, let me go back to my email with Reba earlier today. I had a couple of things that were more grammatical, but it seems like I had one more substantive one. Oh, so, I mean, she said she was going to take a look at this, but it did seem to me like we talked, the start of the thing talks about providers and operators, and then somewhere in the middle it shifts to licensee, and licensee becomes the more dominant word, and we don't actually have a definition of licensee. So I think, we just want to try and clean all that up and know what those three terms mean vis-a-vis each other. I think we probably need a definition of licensee, and we probably need a definition of network. We also replaced the word system with the word network, but we didn't define that either. I mean, I guess I gather from your response to me that you think all these people know what that word means, and they probably do. They probably know a lot better than me what that word means, but it's...
I love clarity. So I think we should probably add a definition.
And honestly, I did have that conversation about network and system with Nancy when she was on board about that. And I'd have to go back through my notes to look at those definitions as to why we didn't define it. I know one of them is defined in either ORS or the FCC, so we wanted to leave that and not...
Well, and so you could cross-reference that, right? You say network as defined in... Yeah.
Well, and we kind of did do that in the definitions. We added in the definitions work session page 4 that when it's not inconsistent with the context, words not defined herein shall be given the meaning set forth in the Communications Act.
That's right.
And the Telecommunications Act. If not defined in those statutes, the words shall have their common and ordinary meaning. So we added that to make, and that was part of that discussion I had with Nancy, is to give that the common and ordinary. And then we changed or clarified what the term facility meant. System is kind of a leftover from before, and it's now more of a network. They're not running a cable system. They're running a network that provides not only cable, but telecom and wireless and over the top. So it's kind of more of a loose term, so we wanted to leave it a little bit generic, and then when we wanted to get specific, we used the term facility in the code. And then for the licensee, and I will go back and look at that, and I apologize, we wrote this back in February. We defined operator and provider as two different things, and then we talked about the licensee in, I think the first place it appears is when we talk about the fact that they need to obtain a right-of-way license. And the thought was that once we tell them they need to have a right-of-way license, they are then a licensee, and that's a pretty common term. But we can, define a licensee as somebody who holds a right-of-way license from the city of Milwaukie. We can add that.
Yeah, or it may be, I would definitely defer to you to discuss with council, but it may be that you, in your definition of operator, you say once an operator receives a license, he's referred to as a licensee or something. I don't know how the best way, whether it's to identify licensee standing alone or identify licensee as an alternative word to operator and provider, depending on where in the stage of the process they are. I don't know. It's just like Ann said, it's just, we need to make sure it's clear.
And I will definitely consult with the other jurisdictions, and I don't know if you know, but Nancy, who was our row attorney, is now the national attorney, and I'm still connected with NATOA, so I will reach out to her as well.
She moved to D.C.?
No, she's always been in Chicago.
Okay.
Yeah.
She's in Chicago. And I actually will see her in the last week of August. NATOA has their national get-together, so there'll be a bunch of attorneys there. So I will, actually, I'm coming back to you before that. I'll call her.
Yeah.
And I'll reach out to the other attorneys on the serve.
We do define right-of-way license or license means the authorization given to the, so I think you could sue licensee very easily, meaning one who has obtained authority from the city to do it. I mean, it's a very easy definition to add.
So just for clarity from council, do you want me to add a definition of licensee, or is that clear in the text that someone who has a license is a licensee?
I would love for a definition to be added, and I'm not counsel, but I would love for that.
Okay.
Yeah, I agree with that.
I'm fine with it.
I think it's good to give the whole thing a read over and see where your transitions are between those terms, and just
Yes,
make
I will
sure
definitely
you
review that.
want to.
It was February, so apologize. Lots happened since then.
Yeah.
Just a couple things.
Okay, that was all mine.
I did want to point out, too, also, one of the changes in the code was our enforcement procedures on late payments. There's a big reason for that, as staff spends a lot of time chasing down people, providers that have not paid us on time. And it takes a lot of my time to do that. And the way we originally had the late payments charge for late payments was very confusing, very complicated. This is just a simpler, easier way to enforce late payments. You're late, this is the charge.
And does that go into effect? I mean, do we have to give them all notice? Do they all get notice that this is on our agenda whenever it's?
Well, my plan was to bring this to you tonight and get your feedback. I'll take your feedback, make the adjustments that are necessary and needed, bring this back to you on the 21st, and if that's what you want to go with, my plan, the thought is to have it effective October 1st, which is the new quarter. So after you approve it, if that happens, I will then send notice to all the known providers saying there has been a change to our code. Please go here, look at the changes to our code.
Are you wanting to notice them?
Well, I don't know if we have to legally. I mean, generally, we like to give people notice when we're doing something that affects them.
Right.
And there was, I know we heard from at least one that was not given notice and was surprised that they were affected by the original row.
Yes, I remember that.
Right.
So how many entities are we talking about?
Well, we have issued 40 row licenses, or issued 39, and I approved another one yesterday. Those are the ones we know of that are in our rights of way. There are still a lot of providers, staff believes there's a lot of providers that have not complied with the city's codes. We do give public notice in the form of posting these to the internet. I think that is public notice. If they are doing business in our city, they should know what's in our city, and the changes on this code that I'm proposing, if they are complying with our code currently, it would not affect them in any way, shape, or form. It only affects the people that are not complying with our code. We did notice hundreds of providers in 2017. Actually, 2016 in December, after you adopted the code, we started noticing. We noticed again in January of 17. I sent out notices again January of 18. They should know that we have this code. And as I said, the changes we're making, if they are in compliance with the city's codes, it will not affect them. This only affects people that are not in compliance or are paying us consistently on a late basis.
So it seems like the question of if we've got 40 and you think there are 200, how we get to those, that's a discussion probably for another day. But for those 40 that have complied, even if they're late payers, they're in compliance generally, maybe we should be giving them notice, don't you think? I mean,
I think we definitely should, and I think we should, if we change it, if we're just having a conversation,
Right, but what
Well, I mean,
Council
notice
Beatty
so
is
that they can
suggesting, so they
comment
can
if
come
they are
testify
inclined to comment.
when we are about to make the decision.
Oh, okay.
So that if they strongly disagree with something that you've proposed, they have an opportunity to tell us that.
Would you like me to send out notice of this meeting to those people so they can review the video and let them know that it's coming up on August 22nd as well if they'd like to testify?
I think that would be good.
Sure.
Be fairest.
I think it's the 21st, yeah.
Yep.
Yeah.
Notice all current row users are the ones that we know of?
Yeah.
Yeah.
Okay, so it would take me a while to get a letter out to everybody I believe is.
Yeah.
Anything else? Thank you very much, and most impressive.
Thank you.
I remember that when we were thinking about would it be a good idea to have right-of-way staff, and there was this concern of, well,
How much was it going to cost you?
The previous city manager said we were losing money, and he was right. He was obviously.
Wow, you make a lot of money.
We haven't even started yet, to be honest with you.
Yeah.
We've got a lot of work to do. Thank you so much. I'll see you on the 21st.
Thank you, Reba.
Thank you. So, nothing else except executive, right? Upon adjournment of the work session, council will meet in executive session pursuant to Oregon Revised Statute ORS 192.6602, A, to consider the employment of public officer, employee, staff member, or individual agent. H, to consult with counsel concerning legal rights and duties regarding current litigation or litigation likely to be filed. It looked like there was three. Just that.
There's an E.
And executive items A and H added to the agenda on.
So there's an E above it, right above.
Oh, it's not highlighted. That's why. And E, to deliberate with persons designated by the governing body to negotiate real property transactions.
Perfect.
You just highlighted the changes, like I would have memorized this thing otherwise. Thank you. So we are adjourned.
Do you guys want to go get